Hey everybody, this is Joe Murphy from Allegheny Immigration Group. I've got a video for you today about a situation where people want to get a green card for their spouse who lives overseas. I've had more than a few inquiries about this subject lately. Joe, how do I get a green card for my husband that lives in Nigeria, or my wife that lives in Peru, or my significant other that lives in Russia? Anyone who wants to apply for a green card has to already be physically present in the United States. You can't apply for a green card from another country. So the trick for the citizen spouse is how do they get that foreign spouse from the foreign country into the United States so they can apply for a green card? There are two ways that the spouse of a United States citizen can enter the United States. They both involve the issuance of a visa. One type of visa is for spouses that want to come into the United States and just visit for a short time and then go back to the foreign country. That's called a K-3 visa. The other type of visa is for a spouse that wants to come into the United States and apply for a green card based on their marriage to a citizen. That's a different type of admission and it requires a different type of visa. Normally that's called a CR1 visa. There's a lot of demand on the immigration system lately, and things are starting to take ridiculously long time. Right now, it takes 16 and a half to 21 months for the issuance of a CR1 visa when it's a U.S. citizen filing for a spouse, parent, or child. And that's just for issuance of the visa. Once they get in the country and apply for a green card, there's another waiting period that's even longer. One of the things we've been advising our clients to do is apply for both the CR1 and the K3 visa, and that's the just visiting visa. The just visiting visa is issued much, much faster. According to USCIS published processing times, the K3 visa can be issued within 4 to 7 months. Once they come in on that K3 just visiting visa, they're allowed to wait here for that CR1 visa to be issued so they can apply for a green card. It's right in the USCIS fact sheet for I-129F where it shows that a lot of people do file both, and you can too. We can help you with that. So we'll go through the whole process here from soup to nuts very briefly if we can. The basis of any of these visas is that a U.S. citizen wants their foreign spouse to enter the United States. There's a couple things you're going to have to prove. The application is made by the U.S. citizen as applicant on behalf of the foreign spouse, which would be the beneficiary. The applicant has to prove that he or she is in fact an American citizen. You can do that with a birth certificate in one of the United States, a passport issued by the United States, or a naturalization certificate, but you're going to have to prove as an applicant that you are a U.S. citizen. The next thing you're going to have to prove is that you are in fact married to the non-citizen spouse, and you normally do that with a marriage certificate. The applicant also has to prove that the marriage is in fact a bona fide marriage. Bona fide marriage means that the marriage is real, that it's a good faith marriage, and that it's not some faked up green card marriage or something like that. In most cases, it won't be that hard. The classic way to prove a bona fide marriage is to prove that the spouses have behaved in the way that North Americans expect spouses to behave, and that is generally defined as commingling a bank account together, listed as beneficiaries on reciprocal life insurance policies, a lease or real estate owned together. The ultimate evidence of commingling, and therefore bona fides, of course, would be the birth certificates of children born of the marriage. So the applicant has to prove that he or she is a citizen, that he or she is married to the foreigner, that the marriage is in fact a bona fide marriage. They also have to prove they have the financial ability to support the non-citizen spouse if in fact the visa is granted. The government's very concerned about admitting, so to speak, public charges, people that will become dependent on welfare to survive in our society. If you're the applicant and you're sponsoring a foreigner to come to the United States, the government wants to make sure that you've promised to take care of them, that you will reimburse the government for any public services that your non-citizen spouse may need to use while they're here in the United States, and that you have the means to make good on that promise. And that is normally done by showing your tax returns. There's a base amount you have to show. You don't have to be rich. You just have to have enough income to live at 125% of the poverty line for you, everyone already dependent upon you, and the foreign spouse.